Judge Rainwater, there are three distinct parts of your professional career that I would like to talk to you about. The first, of course, has to do with your career as a lawyer. The second, your career as a politician and a person very involved in community activities. And the third and final, your judicial career. So let's begin with your legal career. Your career as a lawyer, which had a rebirth in March of 1946.
Correct, upon return from service.
And you joined up with your father again in the firm of Rainwater and Rainwater.
Correct.
Now, these were days of post-prohibition, and of course I'm from Sevier County, you're from Jefferson County, we're from neighboring counties, and we were right in the center of the Bible Belt.
Correct.
But that didn't mean that people people forsook the use of alcohol in our area, did it?
No, people used it and weren't going to be denied.
And one of your first cases, and I suspect you had many, regarding a moonshine still of some kind, but one of the more memorable ones took place in 1947 and involved the Jefferson County Sheriff's deputies.
Yes.
Tell us about that.
As you know, English Mountain is a mountain that runs along parallel to the Smokies, north of the Smokies. And it was the grounds for people in Hancock County, Sevier County, and some of the other counties on the east.
Our family's excluded, of course.
Yes, yes. That their livelihood came about from making moonshine whiskey and running it into Knoxville and Asheville and these places, and that was their bread and butter. And on this particular occasion, the federal marshals who had responsibility over illegal manufacture of alcoholic beverages were very active. The local sheriff was very active to show that he was doing his job. And then, of course, the state was interested to a degree, but not on an everyday basis. Well, anyway, on this particular occasion, the local sheriff of Jefferson County had been, he and his deputies had been staking out a moonshine still operation on the top of English Mountain, which was right at the boundary line of Hancock and Jefferson County. They decided they watched it while they let the mash ferment, and to judge at the time that the operators would be back to run off the mash and turn it into moonshine whiskey. So they received the word that time was going to be on the early morning of, I don't remember the exact date, but anyway, the sheriff, the local constable, and two of his deputies decided that they would go up early in the night and stake out their position and be there when the operators of the still came to work the next morning, and then they would arrest them and charge them and bring them in. Well, as it turned out, they did that. They went to the scene, and when the people came the next morning to operate the still, and when they flushed themselves out, that is, the county officers, at that same time on the other side of that, a group of officers, later identified as federal alcohol agents, had been there all night doing the same thing. Not to the knowledge of the local sheriff, or the local sheriff was not knowledge to the federal people. And guns started firing.
At each other?
At each other. And not knowing who each, they thought, I'm sure that the sheriff's people thought that the people on the other side were in cahoots with the moonshiner, and I'm sure the feds felt the same way. As a result of it, Jim Thomas, the constable from Jefferson County, was killed. The sheriff, who's Arthur Halbert from Jefferson County, received serious wounds from guns. And a deputy sheriff, his last name was Glass, received a shot in the arm or in the shoulder or something. It wasn't serious, but it was certainly unpleasant. And
Any injuries on the other side, or were they all to the?
I don't think they, as I recall, I don't recall of any, but perhaps there were some. It was not life-threatening or anything of that nature. Well, of course, that caused a newspaper row here about the feds, that feds came in unannounced, and that it was the primary duty of the local sheriff and whose county it was to be there, and they should have been notified. You can imagine all those things that were going on. And feelings got to run pretty high, and it was decided by General Wolfenbarger, Joe Wolfenbarger, who was Attorney General for Hancock and Jefferson, as well as Sevier County. He brought charges against the federal officers before the grand jury in Scott County, I believe, and got returned true bills on assault on these particular federal officers. Well, under the laws that existed in those days, the state attorney general, who had jurisdiction over the venue of the crime, alleged crime, brought the charges in state court. And when the charges were brought in state court, they were automatically transferred to the federal court for trial. And the United States District Attorney represented the defendants and presented and handled all their defense. So the case came to trial in the federal courtroom here in Knoxville, and which is over in the old post office building at that time. And a several-day trial.
Who was the prosecutor?
Joe Wolfenbarger was
the local DA.
Yeah, see, he was the Attorney General who was charged legally with the duty of prosecuting if a crime had been committed, you see.
So this was the unusual situation of a district prosecutor going into federal court to prosecute federal agents who were represented by the U.S. Attorney, who generally was in the business of prosecution.
Yes.
What happened?
The jury found that the officers were not guilty, and rightfully so. Nobody intended to do harm to the others. It was a mistake on everybody's part.
And your role in all of this?
Well, we represented the sheriff and the family of the constable, and we in those days you couldn't file suit against the government for damages. The only recourse was to go to Congress. So we spent the next 3 or 4 years trying to get a bill through Congress to reimburse these people for their injuries, and we're eventually successful. We got a $10,000 for the sheriff for his injuries. They're pretty severe. He was in the hospital for quite some time. And I've forgotten exactly what happened in the constable's case. It seemed to me like they found some other way to remunerate, made a settlement with his family. I just don't recall. It's been quite a while.
It's been a few years. Mm-hmm. Well, that was in 1947, and in the 40s and 50s, your firm, as I recall, continued to build its reputation not only in its real estate expertise, but also in the trial practice, and much of which was civil. But you, from time to time, engaged in the criminal practice as well. And you had some fairly high-profile cases during the 1960s and 70s.
But not at my solicitation or making myself available. I was appointed in those cases.
Perhaps we should point out that this was in the pre-public defender days, and really the practice at the time. Perhaps you could explain how indigent defendants were represented by counsel in those days.
Well, the presiding judge would make the appointment of attorneys to represent the defendants, and no means of funds for investigation, for whatever it might need to get ready for trial, and certainly nothing for compensation to the lawyer. Criminal law was never one of my favorites. What criminal law did, I might say, under compulsion to a degree. It was either somebody that I knew closely or had some obligation to try to help out, or being appointed and having to sit to with a judge and called him everything you could think of for calling you and making that appointment and seeing if he wouldn't back off. And then some judges that you were familiar with, they seemed to gloat over making us unhappy.
Well, we had one of the longest running circuit judges in the 4th Judicial District, in Judge George Shepard. I guess it was the 2nd Judicial District in those days. He continued to run for re-election until he was in his 80s, and ultimately defeated in 1974, but he was basically the law of the land.
Oh, absolutely.
In the years prior to that. Did he try all of the criminal cases in your county?
Yes.
And was he the man you were talking about that would usually appoint you to represent the criminally accused?
Well, in the Hancock feud case, he was. In the case of the Nunley case that came on later, Judge Porter was his presiding judge then. Shepard did. And what other case? I've forgotten what other.
Well, we'll have several, and let's take
right.
that Hancock shootout first. It was a 1961 case. Tell us about that.
This was in the spring of 1961. Hancock County, if you're not familiar with it, is a small county on the Virginia border on the extreme northeastern section of Tennessee, a county back in the mountains, a small county, a population I think at that time was only about 3,000 in the county. It's a county that is known as where the Melungeons settled in Tennessee, coming across from North Carolina. Been several books written on that. And a feud developed in the political feud in that county between the then sheriff, who was Verlin Maxey, and the other faction, the political faction, headed by a gentleman, older gentleman, the name of Matt Oakes. And they couldn't get along, and a son of Matt Oakes was a constable. And they were sniping back and forth at each other whenever they could, politically and otherwise. And on an occasion, the sheriff or his deputies arrested the constable and charged with drunk driving. Well, came before the grand jury, and the grand jury returned a no true bill. And that upset the sheriff and his political group no end. And obviously it was going to be tit for tat. So on this particular occasion, the sheriff was downtown, little town there of Sneedville, and early in the, well, 8 or 9 o'clock in the evening, there's one traffic light in the town, one main street, and the sheriff found that the Constable Oakes was at a bar, or whatever you want to call it, and obviously probably drinking. And the sheriff set out to set him up and arrest him. So the sheriff parked his cruiser on the main street where the Oakes would have to come out to go home, go to his father. And then he was going to run him down and try to stop him and whatever, what he had on his mind, we don't know. But when the constable came out to the main road here and turned to go to his father's house out here, half a mile, he saw the sheriff's car there, and he speeded up, made a sharp turn, loud scream, and ran a red light, just ran through the red light, obviously purposely. So the sheriff...
So they had a red light in Hancock
They had a red light, yeah. The only one. And so the sheriff took off after him and got on his radio and notified his deputies. And the constable drove out to his father's and drove in his driveway to his right. It went up a little rise there and on over the rise down to where the garage was. He stopped the car and was getting out of the car, and the sheriff drove up right behind him, and the sheriff was getting out with his gun, and who knows, started fired first, but the testimony was not real sure of who started what. But anyway, they both were shooting at each other, the constable and the sheriff, and the constable was killed. And about that time, six of the family, 6 men of the family, either in-laws, cousins, or something, who were in the house, came out of that house, went to the sheriff, started beating him, took his gun away from him. Just absolutely beating him within an inch of his life.
And their family was named Myers, as I understand.
No, their family was named Oakes. These Myers were married into the family, and I never did find out all the details.
But they were part of the Oakes
they were
clan.
They were part of the Oakes clan. And then about that time, 2 deputies drove up and stopped down on the main road, and were getting out of their car when both were shot in the back with a rifle and killed right there on the spot. They just died right off. Anyway, they got some other people by that time came in and kind of restored some order, got people carted off to the hospital. They brought the sheriff to Knoxville and picked up the dead and then arrested the others. And it was really something, and it created turmoil in that county and that whole area up there for weeks and weeks and weeks, and of course resulted in the indictment of all of these defendants. That's all 6 of them for assault on the sheriff, murder of the 2 deputies, and a number of charges. It was terrific what they were. Anyway, we had 200. Now, Ed Hurd, the lawyer from Newport, and I were appointed to represent 4 of these Myers. And we to represent them. Yes, I know. we had 294 preemptory challenges.
In a county of 3,000.
In a county of 3,000. When you add it up, take all the charges that were placed against all 6 of these and give them their maximum, it totaled up to 294 preemptory challenges. Now, can you imagine anything like that?
But you got a jury.
Got a jury finally, after 3 weeks. But we'd have to try like meet today, and we'd maybe get 1 or 2 or 3, and then we'd have to adjourn for 1 or 2 or 3 days so the officers could go out and set up roadblocks, bring people in, and it was something. And the atmosphere was so tense that we as lawyers couldn't go into the county. They wouldn't let us go into the county unless we were with highway patrolmen. The highway patrolman would pick us up, pick me up in White Pine and go to Newport and then come across with Ed Hurt.
Of course, neither of you were being paid for your services, nor being reimbursed for your expenses.
No. And we, of course, feelings in that courtroom. The Oaks faction sat on one side, the other faction sat on the other side of that courtroom, and you could cut that with a knife. The atmosphere was that tough, and you just had to be on your toes. And but
this was Hancock County's answer to the Hatfield and McCoy feud.
That's that.
And you actually got a verdict in after
we tried
days.
the case. Of course, we were not going to. The defense was not going to ask for a change of venue because they had too many relatives, and you couldn't get a jury that didn't have some relative of some of these defendants. So we tried the case after we got the jury. After about 3 weeks, we tried the case and got all the proof in. And as soon as we got the proof in, Judge Shepard adjourned court and transferred the remaining proceedings to Jefferson County. He said that all the law required was that it be heard, the proof and the evidence in the county in which the crimes were allegedly committed. And that then for the closing argument and the instructions to the jury in receiving their verdict, he could do that in another county without the defendant having requested a change of venue. So they moved it to Jefferson County. We argued the case for a day or more, I guess, and the jury was out nearly a week. They went out, well, practically a week. And the judge would call them in, and they would say, well, we're still working on it. And on Thursday night, about 10 o'clock, the judge called the jury in and asked if they'd reached a verdict, and they said, yes, we have. And he said, all right, what is your verdict? And they said, we find, and they named 4 of the Myers not guilty. We find the other 2, Horton and whatever his name was, I've forgotten.
His name was Carl Myers.
Yeah, that's right, Carl Myers. We can't agree. And no, wait a minute. No, they found them guilty. That's right. They found those 2 guilty of assault and the judge was writing that down. He looked over at the jury and he said, now, what punishment did you fix for the 2 that you found guilty? And the foreman stood up and said, we can't agree. We can't agree on it. And the judge said, well, under the law, as it existed then, the jury had to fix the punishment.
In order to set up this conclusion to this story, the listener of this interview should be aware that there's a reported case on this. The Tennessee Supreme Court ultimately decided this case, and the case is 351 Southwest 2nd, 385, a 1961 case heard by the Tennessee Supreme Court, before there was, by the way, a Tennessee Court of Criminal Appeals.
Yes.
But as you indicated, James Horton was found guilty of felonious assault on Berlin Maxey, and Carl Myers was found guilty of assault on Berlin Maxey as well. And then the jury did report that your clients, and that of Ed Hurd, Earl Myers, Dean, George, and A. Myers, were all not guilty. And then when Judge Shepard asked about the punishment, the foreman said, "Judge, we left that up to you." And this is what created the problem.
That's right.
They began their deliberations again.
Judge sent them out, said, "You have to do it." That was Thursday night. Never will forget, the coming Saturday would be September the 30th. Auburn, Tennessee football game in Knoxville. And everybody involved, that is the lawyers, judge, and all, were not going to miss that ball game. All of course, had tickets. So the judge came back on Friday. I said came back, he'd go home after they would report. On his own, or if they thought they were coming in, we'd call it. And he came back on Friday, and they still couldn't agree. And he charged them again and told them it was their responsibility and they had to do it, and you know. So
as an aside, Judge Rainwater, if memory serves me well, in 1961 you'd probably had more fun in the Jefferson County Circuit Courtroom than you did Saturday at Shields-Watkins Field in Knoxville.
Well,
I think Tennessee was shut out that day by the Auburn Tigers.
I've forgotten now what the score was, but anyway, on Friday they still hadn't agreed. And he said, "Well, spend another night." And they came back on Saturday morning about 10 o'clock, called the jury in, "Have you agreed?" And "No, Your Honor, we can't agree. We can't agree on anything. We take back all we've done." Judge looked down and said, "What?" Said, "Yes, we take back what we did. That we can't agree on anything now." So the judge was in a quandary. Anyway, he had noted on his docket when they first reported it not guilty, he noted not guilty on it. And so anyway, he said, "Are you sure?" And you know how the judges would do to try to get them to force them. The old Allen charge, I don't know whether we had the Allen charge that far back or not, but anyway, he gave it to them. But they just said flatly that they couldn't reach agreement. So he discharged them, and but required them to stay in jail. Required
your clients to stay in jail.
So we set about immediately to file a habeas corpus. Those people had been in jail, and they had been moved over to Jefferson County Jail. Well, they were in Jefferson County Jail even before they started the trial at Hancock County. That's right. So we filed a petition of habeas corpus, and the Supreme Court was meeting here in Knoxville in this very room a week. I see that was on Saturday the 30th, and they were meeting a week after that. There's a week in there, and then they met on Monday, whatever date that fell. So we got with the Attorney General and stipulated the facts and got up hurriedly our briefs and got it submitted. And due to all the publicity throughout the state, and the Supreme Court agreed to hear it. And they put it on their docket, the end of their docket on Monday, the first day here, their September term here. So we came down to argue the case. They heard, as I say, the other cases. Ours was the last, and they went through the lunch hour and got to us about 1 o'clock, and we presented our case. There was no one then in the courtroom except Verlin Maxey, who was the sheriff, who had gotten all this beat up and so forth. So he sat I'm turned around right now, but he sat right back there in the corner. And we knew he was here. And of course, we were over here at the council table. Clerk, John Parker, was over here. And so when we got through, the Supreme Court got up and marched out the door. And as the last justice went out the door, this Verlin Maxey got up and he came running right straight to us. And he got to the table over there and he's just shouting and raising his arms. He said, "You SOB, when you come back to Hancock County to retry this case, I'm going to kill you all." Well,
obviously you've cleaned that up just a little bit.
Well, I didn't quote some of the language. And we were just standing up talking, and he came in with that. Then the clerk and the bailiff here went running out, and they grabbed the phone and called the police. And so Maxey then turned and ran out the door and got out of the building. By the time the police got here, then they wouldn't let us leave until down in, late in the afternoon, afraid that he might be sitting out there to ambush us. So we got through that, and then that was the night that the local bar always had a luncheon or a dinner for the Supreme Court at the Andrew Johnson Hotel. And we stayed for that. And we were having our social hour, and one of the Supreme Court justices, just in kind of passing, made a remark that he understood that they was told what had happened after they left, and he would apologize on behalf of the court for us having to be involved in that, but they recognized what happened, and they kind of tapped me on the shoulder and said, "Don't worry."
I guess you felt better about your case then. And only
I thought that sealed it. I knew that had that happen, but it was, you can't understand it unless you could put yourself in the pressures that were brought to bear on everybody involved, and it was a serious question for the courts.
And of course, within days after the jury verdict, you had an opinion from the Tennessee Supreme Court.
That's right. Mm-hmm. Just a few days, and published opinion.
Expedited appeal.
Oh, yeah. And they affirmed the trial judge's entry of not guilty, and that was it. That was it.
Judge Shepard was a colorful character, to say the least. He was from Newport, and he was in the newspaper business
and a
circuit judge.
A brilliant man.
Tried both civil and criminal cases during that era, and he was defeated in 1974 in an election with one of your old friends, J. Kenneth Porter, who was circuit judge well into the 90s from 1974. Early on, he had the reputation of trying cases and trying them until they were over, regardless of the time of day
or night.
Did you experience some of that during the 1970s?
I lived with it year after year. 10 o'clock was just normal. 1 and 2 was occasion.
In 1974, you again were appointed to a high-profile case, the case of State versus Richard Nunnally. Does that one stand out in your mind for any reason?
Well, yes. I don't want to bore the people with these tales, but this involved Hancock County again. There was a young man by the name of Richard Nunnally who lived in Knoxville and was starting out in the contracting home building business. And he had contracted to build a home for a couple from Georgia who had bought some acreage in a rural area, well, all of Hancock's rural area, but of Hancock County, and was in the process of building a home for him. And apparently some difficulty arose between the contractor and the owners, man and his wife, and the owners had gone on this particular day to the courthouse and taken a warrant, a criminal warrant for the contractor for misappropriation of funds. It claimed that they'd paid him and he hadn't done the work and so forth and so on. And a few days after that occurrence, the sheriff of Hancock County went out for some purpose out this to where the home was being built. And when he drove up, he found a van belonging to the Georgia couple sitting in the driveway beside the home under construction. The husband was sitting on the steering wheel. The wife was in the passenger seat, dead, had been shot in the back, sitting in the vehicle. And as a result of that, charges were later brought against this contractor, charging him with, of course, first-degree murder of those two people.
Were you hired as counsel in this case, or were you appointed by the trial judge?
My good friend, Judge Porter, well, see, ordinarily it was going to be tried in Hancock County. But what it precipitated, I don't know. They decided to change it to Jefferson County, to have a trial in Jefferson County. Judge Porter had appointed Clyde Dunn, a lawyer in Newport, to represent Nunley in the Hancock County case. But then when he moved it over to Jefferson County, he wanted a local attorney. That is, I say, Judge Porter. So he called me. We had a not too friendly conversation, and but he wouldn't relent, and I had no choice. And so Dunn and I represented Nunley, and it was a bitter default case, but totally a circumstantial case. There was not one they couldn't find, never found a gun, a weapon. They had no motive other than the fact that they'd taken out a warrant for him, but it hadn't been served on him. Whether he knew about it or not was an issue, and it was a tough case to be tried from the standpoint of the prosecution. And so we went to trial, and there was a lot of feeling over it. Those people in Hancock County they stick together, and they were not in sympathy with the defendant in any way. And so we tried the case. It took several days. And one of the things that occurred during the trial of it was the defense was we tried to get into evidence the fact, as related to the defense counsel, that the defendant was an informant for the FBI, worked in the FBI, and we'd been an informant in the area, and that we were trying to establish his credibility as a witness. And we started asking about him, and the Attorney General objected. The court sustained the objection, and of course wouldn't let us go into that. So on cross-examination, after some period of time, being examined by the Attorney General, and they closed his examination and walked back over to the table and, was thinking, and turned around and he said, Mr. Nunley, is there anything about this case that you know that you haven't told us? Well, just like that. He said, yes, sir. Yes, sir. I know a lot about this case. I haven't told you. And then what do you do? What's that attorney do? So he stood there, you know, we've all been caught in that situation. Finally, he said, well, why didn't you? So he shot right back, and he said, well, my attorney tried to bring it out, and you objected, and the judge had sustained it. We couldn't talk about it. So that was the end of the cross-examination, and from the defense standpoint, we just sat down. And so the jury came in about 11 o'clock at night, I guess after it's over, and they were hung, 9-3 for acquittal. And with their hung jury announcement was made to the judge, he was not very happy about it, and he had a habit of using that gavel and coming down. You've been a recipient of that, I'm sure. And
been there, done that.
you can hear that all over the courtroom, and the court reporter with her earphones on jumps all the way to the ceiling. But he gavelled and adjourned court right quick and went down off the bench out into the hallway out there. And I don't know why, but I just followed him, just right on his heel. He didn't know I was following him, I don't think. He got out in that hallway, and the first thing, nobody out there. And he said, we'll get that so-and-so the next trial.
Judge Porter was never one to hold his opinions back.
No, and he's a good judge. I'm not, but he could keep from taking sides at times.
But that made you that more.
Well, I was just determined that it come, you know, high water, if there was any way that legitimately that services I could perform or have anything to do with, that I was going to try to see if we were successful.
And in the second trial, what was the result?
Not guilty.
So there's no reported case on that. The state did not appeal.
No, nothing to appeal.
So much for your criminal cases. In Sevier County, you were known for in a totally different light. You had mentioned the moonshine case earlier in the interview, and how that was not uncommon in our area during those days. But in the early 70s, again in the middle of the Bible Belt, the big issue was legalized beer in many of the counties. And in Sevier County, you're remembered as the man who brought beer to Sevier County over the objections of the Sevier County Beer Board.
Not loved by it.
Well, it depends on who you ask these days.
Well, that's true too, but by and large, I'd say.
Well, you represented the Collier family in Sevier County in a Supreme Court case in 1974. Suffice it to say, you won your case, and really, I think you know this, and certainly I do, that there was a lot of beer being sold. It just wasn't legally sold during those days, and you brought it into the light of the law. Let's move briefly into your political career, which was quite a career, and of course it began early through your hanging out at the courthouse, and I suspected that you inherited the Republican Party from your father, didn't you?
Oh yeah. Well, of course, as you well know, Jefferson County was totally Republican. You couldn't be a Democrat in Jefferson County and amount to anything politically, I'm talking about.
And in 1951, you were elected to serve in the House of Representatives.
In the election was in 1950, but served in 51 legislature.
The governor was?
Gordon Browning.
And was this the era of Boss Crump of
Yes,
Memphis?
Yes.
So you were in the midst of that when you went to Nashville to represent your area. You only served for 2 years. Why is that?
Well, it was a flotorial district, the 4th flotorial district, composed of Hamlin and Jefferson County. And we had an agreement, the Republican Party did, that would alternate, that Hamlin County would furnish the representative for this particular term. The next term, we go to Jefferson County. And we lived by it religiously.
And so you did not run for re-election?
No, I did not.
But in 2 years, you were a candidate again, this time for the first conventional or constitutional convention in the state of Tennessee.
Correct.
And quite a historic group there. Several former governors made up that convention.
The greatest group of individuals that has ever assembled in the state of Tennessee, in my opinion, barring, I can name three, I'm one of the three that would be excluded from that group. But we were young, the three of us, but it was...
You three young men are all esteemed members of the bar these days, and I think to mention the other two beside yourself who were just kids at the time, really.
J.D. Lee was I believe, the youngest, and Robert Ogle, Bob Ogle of Sevierville.
My former law partner.
Your former law partner. And myself, we were the babies of the convention, and no way that we could in any wise stack up against the great majority of the people there. If you take the list of the people that formed that convention and leave out those three, due to our infancy, if you want to say it that way, you'll agree that
Who chaired that convention?
Well, it got down to Prentice Cooper, and Cecil Sims was. We had an awful fight over the.
Prentice Cooper, a former governor. Cecil Sims, the founder of, or at least one of the original partners in Bass, Berry and Sims.
And Governor Hooper. Now that was Ben W. Hooper, who was Republican governor in the 1920s, just an outstanding person. And I had the privilege of driving him from his home in Newport back and forth to the convention and to get to pick his brain as to things that had gone by. He was certainly a wonderful person.
Do you remember Governor Jim McCord, who was also a delegate?
Yeah. It was his administration that brought the first sales tax to Tennessee, and he heard about it.
and there were some judges, later to be judges, who were part of that. Chief Justice Ross Dyer was a delegate. You recall?
Oh, yes.
Chief Justice Dyer.
Yeah, very well.
And you remember appellate judges Mathern, Carty, and McMurtry were all a part of that group. And certainly, as you indicate, an esteemed gathering of.
You know, interesting in that connection. While I wasn't serving in the legislature at the time, but I was working the legislature on behalf of a client. Evans Harville's father was a senator, and he has made and got to know him. He was one of the finest persons that you could ever, and it was a pleasure to deal with. You talked to him, and he'd retired at that time as president of Austin Peay.
And you had two successful campaigns. We mentioned those in 1951 and in 1953. But in 1949, you had an unsuccessful campaign.
Ran for Attorney General.
Tell us about that.
That's a political game. I was welcomed into a political organization that consisted of a lot of sitting judges and attorneys and so forth. And at the last minute, a deal was made and fell apart, and I was on the losing end.
Well,
really.
To put this in context, these were the days of political primaries by convention.
Oh, yeah.
As opposed to.
No, it was by ballot. We had election, but it was not a state authorized or no laws. You made your own rules. Each party did. And each candidate who wanted to run had to pay a fee sufficient to cover all the cost of holding that election.
And $2,000 was your fee, and that was a large sum at that time.
That's true.
Well, what happened?
Well,
you had the endorsements of all of the high-ranking Republicans in the district at that time. The obvious question is, what happened? How did your train get derailed?
Well, deals were cut that, of course, I was not a participant in, but I was a recipient of it. That's just politics.
And of course, you were running against an incumbent, Joe.
I was running against a well-known incumbent, and he was finally, at the last minute, persuaded the ruling group of judges and attorneys to swing over and left me out, and that's part of the game.
Well, obviously you learned your lessons well, because you were undefeated in politics thereafter. And you ran several times as well. You also served on the school board during much of this time.
That was the appointed position in those days.
By the county commission. And how long did you serve on the school board?
1954 to 1967.
And were you ever chairman of that
Yes.
body?
Most of the time.
Most of the time. How did you happen to get on the school board? And the next question is, how are you able to stay for so long?
Well, how I got on it, we had the family in Fort Lauderdale on the beach. In summer, it was in July. And Mr. Arthur Holtzinger, who was chairman of the school board and the clerk and master, incidentally, of Jefferson County, had died. And George Zirkle, a member of the county court, we called it in those days, who had the responsibility of filling the vacancy. And they were going to meet within a few days. And he called and asked if he could put my name in and as a board member. And I didn't have time to really think about it or anything. George was an awful good friend and neighbor. And so I told him, yes, go ahead. And so it's been, 13 years.
The rest is history. You were the unofficial, in the sense of not being paid a retainer fee, but you were the county attorney of Jefferson County for 20 years until you became chancellor in 1978.
Yes.
One particularly interesting to me moment in your career as an influential Republican in Jefferson County was the visit that Joe McCarthy made to Jefferson County back on October 13th of 1950. You chaired that event, did you not?
Yes. I was chairman of we had it in Jefferson County in Dandridge, and I was chairman of the Republican Party for Jefferson County at the time, and felt my responsibility to handle it. Carol Reese, at the time, was the head of the Republican Party nationally, and it was Carol's idea to bring down there. See, Carol was in a race with Dayton Phillips for Congress. Carroll had been in Congress many, many years, but he dropped out when he took the position of chairman of the Republican Party, and Dayton Phillips came along and was elected, and didn't want to give it up. And when Carroll decided he wanted to go back, they had to run it down. So Carroll was instrumental in getting McCarthy down here. And we had a crowd, and it was covered all over because McCarthy was making waves all over the country.
You had an interesting story about what his first question was when he arrived in Jefferson County. Tell that story, if you would.
Well, we had set up the proceedings to be at the football field there in Dandridge at, I believe it was 2 o'clock in the afternoon. We were to pick him up at the airport at about 11, and we were taking him to Swan's Millstone Grill, which was a real fancy restaurant for our country. on the lake up there at the Swans, and which was, the restaurant was being operated by Alfred Swan III and his brother-in-law. I'll think of it in a minute. Anyway, and they lived right next door to the restaurant house. So we got in. Took Senator to into the restaurant to sit down, and they came around to order, and he looked up and said, "Don't you have a drink?" And that kind of stunned all of us, and we know around there. And he said, I got to have a drink. And I didn't know what we were going to do, but Alfred Swan spoke up and said, Willard Carter, that's his brother-in-law, spoke up and said, well, I've got some right out the house over here. We'll just go over. So we excused ourselves from the table and went over to the home there. And we got there. Joe, we called him Joe McCarthy. We were kidding around, and he said, I want a drink. And so now the only thing I've got is moonshine. He said, what's wrong with that? And Willard reached up there and got a quart jar and set it down, and had a glass pretty much that size, 8 or 10 ounces, I'd say at least. He poured, Joe, Senator McCarthy, poured that glass full, turned it up, never batted an eye, just drank right on down like you'd drink water. Got up, said, let's go. We went back over, ate lunch. He went on, made the darndest speech you ever saw. You couldn't tell that there was any, that he had anything.
With a little help of Tennessee moonshine, perhaps.
Well, knowing the Swans and the moonshine they had to be good. It wasn't something
that's incredible. I have heard and seen a little bit of moonshine drunk in my days, and I've never seen any drunk without pretty vehement reaction on the part of the drinker.
Well, some of that, 150 proof. If they haven't cut it down, comes out about that.
Well, that's a pretty good lead-in. You had a pretty impressive law practice by then. Obviously, the lawyer in Jefferson County and perhaps the district to employ for those who were looking for a fine lawyer, and you chose in 1978 to run for judge of the Chancery District that included Blount County, Sevier County, Cocke County, Jefferson, and Granger counties. What made you choose to do that?
Be perfectly honest, I was working hours a day that would get me, and I couldn't say no, and I used it as a way out, that I felt like I could hold up my head. And of course, Chancery had always been my favorite. I detested criminal work. I didn't care particularly for tort work, although I did a lot of it. But I loved Chancery. And Judge Ben Robinson, who was Chancellor of our district when I first started practice, was to me one of the most outstanding chancellors that I have ever known.
Lived in Pigeon Forge before there was a Pigeon Forge.
That's right, and as a Sevier County native, as I recall. And he was conscientious, he knew the law, he would help you, and particularly for the young come, if we'd make a mistake, he would politely correct us and set us on the right course. And if there was ever any doubt of which phase of the law that I wanted to be in, it was Chancery.
And you had to earn the office. There was an incumbent by then.
Yeah.
Democrat, our friend from Newport, Jim McSween, was the sitting chancellor.
Gentleman.
And you won handily in the 1978 general election. And served for how long?
20 years.
In 1998, you took medical disability.
Actually, it's the latter part of 1997. I'd been having asthma problems, and I'd been in the hospital 2 or 3 times, and it was weighing pretty heavy on me, and I just decided that I knew I wasn't going to run again anyway. So I just made the decision to step down. That is, take medical leave. I could have come back any time, but everything worked out.
Would you say that Chancellor Ben Robertson perhaps had as much to do as with the way you conducted yourself as Chancellor during that time?
Yes, more than anything else, because I just dearly loved him. You're so nice and pleasant and helpful. None of this midnight business.
And I know that you tried many high-profile cases during this time, and of course the ones I recall are mostly related to Sevier County, but you tried high-profile cases in Blount County, the profit case over the profit stores
stock,
and
stock.
Certainly the J.W. Monsieur estate case in Knox County that you were called in to do. Name a few of the cases that stand out in your mind as particularly difficult or high profile, or that people may remember.
Well, of course, high profile is, I guess, in the eye of the beholder. One of the cases that I guess I enjoyed the most was one of your cases that you filed on behalf of Brownlee Reagan over some property rights in Gatlinburg that was involved just about every issue that you could find in a law book dealing with real property law. And the lawyers, you went on the bench while the trial was pending, and your successor carried on through. But it went on to the Court of Appeals, and it was affirmed. But I enjoyed that. The Five Oaks case there, when they got into litigation over a supposed sale of the Five Oaks shopping center back several years ago. The First National Bank of Gatlinburg case.
You had many.
Well, few.
And you tried a few domestic cases during that time.
As few as I could.
You've tried quite a few. You tried quite a few, and I suppose that you tired of those as time went on.
Didn't take long. Well, I knew going in. I had to deal with some domestic matters in practice.
I'd like to hear your thoughts on what some of the lawyers say about your career as a judge. First, that you liked lawyers, you enjoyed lawyers, and you enjoyed the debate, that you loved the law. That while you were a chancellor, that you had the highest regard for the letter of the law. And then finally, the tougher the case, the better. How would you comment on those descriptions of Chancellor Chester S. Rainwater, Jr.?
I like the tough cases. I like to make law if that's what it is, not because of getting my name on it, but just as to conquer it.
One of the things you always insisted on was the lawyers be prepared when they came into your court. Did you prepare in the same way?
I think I did a lot more than a lot of lawyers ever thought about doing. But I never missed trying many cases that I hadn't read all the files and everything that had been filed in it at least the day before the trial came up. And I wanted to feel like I knew more about that case than the lawyers. And that was not possible in most of them, but I wanted to feel that way.
You know, I want to mention some of your contemporaries, and we're going to wrap up here in just a couple of minutes, but some of the lawyers that you've mentioned to me that you had an especially high regard for and special friendships with were Ernest Taylor, Bill Inman, Ed Hurd. Some of those that you remember as a child growing up around the courthouse that had an impact on your life in Jefferson County, and men that you admired for their skill were J.D. Hale, Court Rankin, and J.D. Park. And
J. Frank Park.
J. Frank Park. Thank you for the correction.
Father of Franklin.
Of the notorious Franklin Park of Jefferson County. And we really haven't talked a whole lot about your philosophy and your approach to litigation resolution, but perhaps along those lines, how would you like to be remembered by your friends and colleagues as regards to the law?
Well, just make it, I hope to be remembered that as having done a reasonably good job, but I cared, I tried, and I devoted the time to do so, and that I hope to be looked upon as being somewhat successful in so doing. That's for others to judge, not me.
We've talked about many things here in the last 2 hours. Is there anything that I might have missed or you might have missed that you now recall that we need to touch upon?
I remember a very enlightening telephone call I received from a lawyer after trying a case all day that he participated in.
And lost. And lost. And what did he say?
Well, after that case that we worked on all day and had an unfavorable ruling to that lawyer, and by the time I got home, the telephone was ringing, and that lawyer was wanting to tell me that this was the first case that he had ever lost, and then had his client come up and hug his neck and thank him for losing the case. And that lawyer
sits with you here today as we end this interview, and thank you so much, Chancellor Rainwater. I wish we had another 2 hours to talk.
Well, I've enjoyed it. I hope that I have answered your question. You're mighty good on. Sometimes we'd have to call you down in court for leading a witness. But,
well, I've led throughout the interview, and thank you very much.
Well, thank you, sir, and thank everybody involved here.